Labdien!
So with the Embassy of the United States. Before we get to our agenda, I would like to repeat some practical and technical issues. Interpretation will be very important. You can watch a streamed version of our discussion in the Latvian language and various online sources like in Facebook, Delna homepage and Zoom. And interpretation you can hear from Delna English section. And if you have connected via Zoom, you can send in questions via chat. And you can also switch the interpretation languages by clicking on the interpretation button in Zoom. So you are welcome to send in your questions via Zoom. Please write them in chat, and the moderator or I will try to ask these questions to the panelists if we have time, because the previous experience shows that the first section is so intensive that we don't have any time for questions. But let us see how it will work out today. So let us get down to the topic. Today we have an expert forum and a roundtable discussion, Law and System of Justice, a tool to fight corruption.
This
is our final meeting in the series of 4 meetings, and this will be devoted to international recommendations on preventing and combating corruption in Latvia and in adopting and implementing these recommendations. And we organize this discussion cycle in cooperation with the US Embassy in Latvia, and this is the 4th such discussion. And today's discussion is devoted to the Latvian progress in fighting and combating corruption, and we will speak about the ability to forecast, to expect risks, to prevent and mitigate risks of various bodies, since this can result in various criminal offenses. We will also speak about the ability to detect crimes and to adjudicate crimes. It is clear that efficient justice is a tool against corruption. So we will keep repeating, keep reminding that in the corruption index, Latvia has stagnated since 2014, and we have had quite a high level of corruption. And Delna has indicated that the Latvian bodies have to strengthen everything, the system, to ensure that corruption is combated, so that people are involved in this fight against the corruption, to demonstrate to the society that these crimes will be persecuted. Law is efficient legislative system is a way to prevent corruption, to ensure that the state is administered in a fair and honest way. And we spoke about this trust in government already before, and the fact that the people do not really trust the government. But in more focused way, we will concentrate on the report published by the European Commission this summer on the justice in Latvia. And Latvia has been criticized for its fight against corruption in various sectors, like in the judicial bodies, in the investigative, and also in other areas. And in the context of these problems that were identified in the report, we have approached today's panelists so that we can discuss these problems. It is clear that such discussions cannot maybe provide universal solutions, will not stop corruption, will not reduce it significantly, because it's such a complex phenomenon and time is going on, and we see ever more that international cooperation here is really critical. This summer we have started to pay attention to the cryptocurrencies and to other aspects to reduce the corruption, fight corruption, and so on.
Šajās tēmās mums ir ļoti svarīgs partners un atbalsts. Tā ir Nīderlandes karalistes vēstniecība Latvijā, ar kuru mēs sadarbojamies vairākos jautājumos. Un tieši tādēļ esam pagodināti, ka mūsu pasākumu atklāja Nīderlandes karalistes.
And we cooperate with the Dutch embassy, and we are very happy that deputy head of the embassy is here.
For public discussion, dear Lieske, the screen is yours.
Paldies. Honorable Chief Justice of the Supreme Court, Aigars Strupišs, dear experts from the Ministry of Justice, the Corruption Prevention and Combating Bureau, and the US Embassy, dear participants and online viewers, Latvia. Thank you for allowing me to address you briefly and share a few words about the importance of the rule of law and the justice system in the fight against corruption. This year, the Dutch Embassy, together with Delna, with Latvian partners and the US Embassy, work together on topics related to tackling corruption and money laundering. Financial and economic crimes go well beyond state borders, and therefore it is key to enhance international cooperation. But combating corruption and advancing transparency eventually starts with strong national institutions and an effective judiciary. Corruption has many faces. It can be an unintentional part of our culture or behavior, like handing over some cash at the doctor's appointment. But corruption can also turn into large-scale and intentional misuse of public funds. Either way, investing in effective reporting systems and protecting those who dare to stand out. It also requires good governance and a strong criminal justice system. Law enforcement authorities, prosecutors, and courts are key enablers for protecting these fundamental values and ensuring that justice shall not prevail. Today's expert forum and roundtable is an important initiative in bringing together experts and decision makers to discuss next steps in the fight against corruption. Today's discussion also builds on the important recommendations that were made at the discussion panel last February on the ability to convict high-level officials, on integrity in business. And for me, this is especially important, bearing in mind the millions of euros that will be allocated with the recovery funds, and the final recommendations made on political integrity. As it was emphasized in the European Commission's report on the rule of law, the core meaning of the rule of law and the need to protect it is the same, even when countries' legal system and traditions might be different. The Netherlands sees Latvia as a committed partner in strengthening the rule of law in Europe. Our embassy will continue to work closely with Latvian stakeholders to support good governance, transparency, and rule of law reforms in Latvia. Finally, I would like to extend our thanks to the organizers of this conference, Latvia's Transparency International Organization, Delna, and the US Embassy. Thank you for gathering us here today. I wish you all a fruitful and inspiring discussion.
Thank you for your support. Yes, we will work together to strengthen the rule of law in Latvia and in Europe. Kā norādīja Lieske de Krijger, jā, mēs nedrīkstam būt iecietīgi pret korupciju.
As Lisa indicated, we cannot be neglected concerning corruption, because that's why today we will emphasize our focus on these questions. In the expert forum, we have invited experts to share with their vision about the progress that Latvia should carry on to make independency of judicial system of judiciary. Therefore, now I will give the floor to Aldis Bukšs. So please, Mr. Bukšs, your floor is yours. Next 15 minutes are given to you. Hello, Chairman of the Highest Court, Mrs. Ambassador, I am really honored to be here. And we are very thankful to Delna for this initiative that Delna has always followed the trends concerning issues that have been always priority to the Minister of Justice, that is fighting corruption. So if you look back at the last 3 years, which Jānis Bordāns has been as Vice President, so from the very first day, this fight against corruption has been one of the main priorities. Maybe that is very comprehensive word, fight against corruption, which could be divided in lots and lots of many small measures. So to show the progress, we believe that during the last 3 years, our competencies in these issues has increased, and we can see this progress if we compare with the previous discussion of Delna that happened last year, February. So it's some 6, 7, 8 months that have passed. And we can name particular things about which Mr. Bordāns already talked in February, which were just in the process expected, but now we see already the results. First of all, we talk about economic court. Economic court started its work, commenced its work on 31st March this year. We have 9 new judges which started work there. And their competency covers also corruption matters on a large scale, official abuse of power. Currently, in this category, not all matters have come, but in general, economic court has shown a very good achievement for the first 6 months. We have heard a lot of references from the sectoral professionals and the efficiency with which these new judges are working. 110 cases have been adjudicated within the first 6 months. And the most of them are concerned with money laundering, some 50, if I am not mistaken, but also civil matters are adjudicated and criminal matters. And the average trial length is 29 days. That is a respectful result. Of course, everything depends on the quality of the judgment. But like I said, we have received a lot of references saying that this is a good beginning. And our task is really to hold this threshold as high as it is, or even bring it higher. And we couldn't achieve that without support of NGO with Delna. Different initiatives with supportive argumentation concerning necessity of this economic court. Foreign Investor Council was a big supporter in this process. So thanks to everyone who helped us to create this economic court. Also in the previous discussion, when we just talked about our vision to make a brand new training center, we have already now achieved the progress thanks to involvement of Mr. Strupišs. We have already earmarked particular financing for this, and the work of this training will be started in 2025. But before that, we will elaborate training programs to train judges, prosecutors, special investigators, judge assistants. And we are talking not about academic learning, but actually about the reform of judicial training system. So this center will provide training for beginners of the professionals and actually lifelong learning. By 2025, because we really want to be really prepared to make good curriculum. Also today, we know as that we have concluded a contract with the current service provider of a training center. So from 2024 till 2025, a new training center will start working. Another progress during the last 6 months is that Crime Prevention Council activities and restart of this council. This council exists already for many years, but its only function was to distribute the confiscated means in the proceeds of crime and other. Right now, council works not only with this issues, but also with the action plan for implementation of recommendations that was approved a year ago. And there are a lot of recommendations, majority of which are based on the so-called judicial audit initiated in 2019. This is a capital audit, and we can see the results, the first recommendations concerning the process of investigation and trial. So these recommendations are implemented through this action plan. Like Mrs. Ambassador mentioned, in fighting of corruption, not only legislative issues are important, what is the situation with legislation, but very, very important is a question of motivation and capacity of institutions and organizations. And here we come to the responsibility of the managers, of the heads of these organizations and institutions. We are also very happy that thanks to the initiative of the minister, there was revised the selection procedure for prosecutors general. It was transparent. We all could follow this procedure. Also, the Helena participated. And Mr. Stukans is working with the best of his heart, and he has not given any doubts about his motivation to really fight these issues that were not discussed before. We are also talking about managers of other institutions, their responsibility about capacity and motivation of their employees to work with these issues. We may have the best laws in the world, but if you are not motivated to work in this field, there will be no result. We have a feeling that for the last year, situation has and is changing in this field, but let's see. Thank you.
Sniegto ieskatu padarītajos darbos un vēl plānotajos.
Thank you for the insight into the project, into the progress and into your plans. So we will closely follow your progress. And as we have already discussed before, yes, in February we had a discussion during which we prepared a list of things to do. And now it's time maybe to discuss our progress during the second part of this conference. And we at DELNA always treat these discussions, these measures as a way to update these lists. So we will keep our eyes and ears open and include various ideas in our to-do list. And to continue this expert forum and to continue with the panel discussion, I'm very honored to give the floor to the chairman of the Supreme Court, Mr. Strupišs, who will provide more detailed information on specialization of courts, on training of judges, and so on. The floor goes to you. Honorable representatives of the embassy, Ms. Tauriņa, dear participants, I'm very, very happy to be a part of this conference and to tell what takes place in courts, what problems, what issues are on their table, what the Judicial Council does. And I have this deep conviction, and I have always told and have always thought that any type of corruption is bad, but if corruption affects courts, law enforcement bodies, and so on, this is the worst type of corruption that you can have. That's why we have to look at this problem from various aspects. One thing is to find those who are corrupt, but the second thing is to create conditions, environments where corruption doesn't pay off. Corruption becomes dangerous. As courts, of course, we do not catch, so to say, corrupt officials because we don't have such structures in the courts. The general national system deals with that, like the corruption combating office, the police, and so on. But the courts have these tools, and also the Judicial Council has these tools to fight corrupt courts. Maybe I will focus on things that we have managed to complete during the previous year. First, it is clear that it is very important who becomes a judge. Thus, it is very important how we select judges. What are the requirements for potential candidates? And if we do not admit those people who should not become judges, at the Judicial Council, we have approved a new selection procedure for the first instance courts, as well as for higher instance courts. And this Friday, sorry, next Friday, says the speaker, because today is already Friday. Next Friday, we will consider the procedure for selecting judges for the district courts. And there are very, very strict selection requirements. And we can see positive results already, because these requirements were applied to the selection of the judges for the economic courts. And we managed to select 10 candidates from 90, not because we needed 10, but just because 80 were screened off due to these very strict requirements. What is also interesting in this new procedure is that the candidate should be assessed psychologically, and there should be a psychologist's report. Of course, we introduced that for the selection procedure to the Senate of the Supreme Court. So we developed a set of criteria for the personality of judges. Honesty, sense of justice, internal independence, true motivation, why he or she wants to become a judge, because we don't need psychopaths just because who want to become judges just because they want to use their power over someone else. As far as I remember, there were 13 criteria that was the basis of specific tests prepared by experts, and all candidates have to complete these tests, as well as they have to complete an individual interview with a psychologist. And the selection committee receives this psychological assessment. And during the structured interviews, they already have an insight into the psychological, so to say, portrait of the candidate, and then they can ask additional questions to cover specific aspects. I think this is a huge step forward. It is an important step forward to ensure that only people who should become judges do become judges. Second, of course, we also develop and we use as a complaint mechanism, because anyone can submit a complaint about a judge, any participant of the case, any party to the case. Unfortunately, the efficiency ratio of these complaints is very low, because mostly those who lose the case, they complain since they don't like the result. But when we study the actual circumstances, the situation, it is clear that no violations have taken place. If we look at the last 2-3 years per annum, I believe in 2 to 3 cases, we have started disciplinary cases against judges from maybe 100 complaints received. There have been also indications or tips about potential corruption, and then this information is forwarded to the respective bodies. This is done confidentially, and I don't know what takes place next because this is not my to follow the investigation process, but the information is forwarded. Third, we also have an internal whistleblowing system that is created according to the law. We have not yet used this system because we have never had any whistleblowing cases. There was one unsubstantiated issue, unsubstantiated case when someone from outside tried to complain, thought that this person is a whistleblower, though this was basically a complaint about a judge. So it was reviewed according to the regular complaint procedure, but for the purposes of law, this could not have been considered a whistleblowing case. In the Judicial Council, we'll also have a working group that looks into the matters that are related to judicial efficiency, because there are very many internal opportunities to improve the efficiency. But there is one large problem, which is the link between the investigation, charges or prosecutor's office and the court. I have said this several times already. I believe also during some of Delna's events, namely, without good quality investigation and good quality prosecution, we cannot end up having a good sentence, a good judgment. I think you all remember the so-called Magonis case, when the first instance found him not guilty. When the complete version of the judgment was made available, I read it and I saw the arguments. And one of the arguments was that some evidence was not admitted, and namely the recording, the wiretapping of a phone was not admitted because it was not sanctioned. But this evidence will be reviewed by the Court of Appeal, which is a normal process. Even maybe though the judge of first instance could have misinterpreted this issue, the appeal instance reviews this once more. But if it really turns out that the investigation powers have been exceeded and the evidence has not been collected properly, then the court cannot really do anything if it really turns out to be like that. But of course, this is a matter of assessment, and I cannot interfere there, and I'm not doing that. I am just explaining the facts. This is just one example, but there are other examples as well, and quite many. Today, during a meeting with the Minister of Justice, we spoke about such issues as problems inviting witnesses. Witnesses don't come. This results in postponing the hearings, and what we can do to make them come to the court hearings, and this also applies to the parties. We have started cooperating with the state police in these matters. I have asked all the chairmen of Riga area courts to provide information which police precincts are not as good in delivering those persons to the court who have failed to appear voluntarily. And when we receive this information, we will see which are the problematic precincts, because this is a problem for Riga, not so much for regions of Latvia. So these are internal problems that during a normal course of action by communication, also with the police, with the ministry, with the heads of the police, we could solve. The Prosecutor General also provided a good example why these witnesses do not come, because the investigation does not filter the needed witnesses from unneeded witnesses. Everyone is questioned, and irrespective of whether this person is relevant for the process or not, all of them still go to the court. But it would have been better if 10 witnesses were selected from 50 instead of sending all 50 to the court. And these are our internal organizational problems that should be solved internally. Remuneration, as well as for judges as well as for prosecutors. My deep conviction is that remuneration of judges should be linked not to the civil servant remuneration levels, but to the remunerations that lawyers of the same qualification receive in the market. Yes, of course, judges could have like a special pension provision with specific ratios, multipliers, but in any cases, basic link should be with the market values to ensure that we get the best lawyers, because there should be some link between these qualifications, because the judge is the final person who says the final word, who makes the final decision. Because if an official violates certain rights, a person goes to the court. And if he or she meets the same level of lawyer in the court as the civil servant is, then nothing happens. And that's why we have to have these differences in remuneration to ensure that the best lawyers work for the court. And I'm not speaking about the Supreme Court, but more about the first instance courts where there is no link with the market level remuneration. And this is one of the anti-corruption measures as well. I think this is quite evident and quite logical. And another aspect of late, the courts have indicated money laundering has become quite prominent, like investigation and adjudication of money laundering crimes, confiscation of proceeds of a crime, and so on. And we see some worrying aspects there that the courts have been underlined themselves, not so much the lawyers, the advocates, because they had spoken about that for a long time, but now even the courts say that, including the Court of Economic Affairs, namely that in such cases it's much easier to violate human rights, considering the specificities of evidence and collecting of evidence, first and foremost, because the money is first seized and only then the investigation starts. You know, it takes a while and the money is frozen, and it's a matter of human rights. And then we just have to ask whether it's justified or not justified. And the courts have indicated that sometimes this money just stays frozen, so investigation is not really going on, because the investigation report could have sent to the code for a long time ago, but it just stays on the desk of the investigator. On Caesar's aspects that we are currently discussing, but maybe it's not so much related to today's topic. This was a general overview of our latest topicalities. So if you have any questions, I'll be happy to answer. Thank you for this brief overview of the latest events. You provided very detailed and constructive information. In chat, we do not have any questions so far.
Thank you for your very detailed interpretation. We have not received any questions yet in our chat box, but we will be able to ask these questions in the second part, and Mr. Strupišs will also participate in our discussion. So please, I remind once again all of you who are connected, write your questions in the chat. Now I will give the floor to Inese Zelča, who is head of the Division #1 Policy Planning of the Department of Strategy, Corruption Prevention, Combating Bureau. We are interested in what they have done and what should be done yet to fight corruption. Please, Mrs. Zelča, the floor is yours. Thank you for the invitation to participate in the discussion. I am honored to tell you about our vision of KNAB and what has been done in the fight against the corruption and the steps to be made further on. The document from 2015 till 2020 is guidelines of corruption prevention and combating Bureau. There were 111 tasks including in this document with the aim to provide a trustful activity of every organization and institution. In total, all institutions of government and local government are involved in this process. Also, capital companies are involved. Currently, we are compiling information about what has been done during the last 6 years, and then we will give the vision. If you look at the final assessment, we can conclude that approximately majority of the tasks have been fulfilled fully or partly. During these last 6 years, Bureau has made all efforts to work on ethical issues, on interest of conflict risks. We have also published explanations in our website. We have achieved that today any municipality, municipal organization, a capital company, a governmental company has to observe the internal supervision system. We have also different regulation, like state officials are prohibited to use their names for some promotion or ads. Everybody has available information today about public procurements. We are excluding tenderers from public procurements who have been admitted guilty in some criminal activities. We are talking about transparency in all those tenders. We are talking about prevention of risks of misappropriation and embezzlement. So, totally, we can say that situation during these last 6 years has improved in the country. However, we still have a lot of place for improvement where we are lacking resources like awareness of pupils concerning corruption because of lack of financing. In 2020, our office started to work on corruption prevention combating plan for 2021 to 2024. This is the next important development planning document in the field of corruption prevention and combating. This will be as continuation for our basic guidelines. The overall goal of policy will be kept, and also sub-chapters of anti-corruption will be kept. This is personnel management policy, excluding possible corruption, decreased tolerance against corruption, punishments are mandatory for criminal offenses, restricting of power in policy. In order to precisely target our goals, our office in 2020 invited the government and local government institutions and organizations according to their competence and experience, gives their proposals concerning measures to be included in the plans. In April this year, during public discussion, CNAB received and evaluated more than 50 proposals from one political party and a lot of NGOs. So we discussed these proposals, and respectively, majority of the proposals on combating corruption or prevention of corruption have been taken into consideration. In July, this plan for the next 4 years was announced in the meeting of state secretaries, and we received in total 95 objections and proposals for precision and clarification of the plan. That testifies that state authorities and private authorities are interested in decreasing corruption and achieving these goals. Provisionally, we have now 70 tasks like prevention of conflict of interests, carrying out research for prevention of conflict of interest in activities of officials. So then on the basis of that, we could give proposals to legislature, like granting of special status to some groups of employees, the proportionality of duties, internal control system and its quality of anti-corruption in the organizations. We will evaluate their anti-corruption plans, how qualitative they are, what kind of information is included there, whether institutions really evaluate all the risks. We also plan in the next years to cooperate with the Ministry of Education and Science to elaborate interactive anti-corruption game and give it to schools. We will also evaluate state budget efficiency for political parties. There are more political planning documents in the country which are related with anti-corruption, risk prevention, like action plan on prevention on money laundering, or plans of prevention council, and there are tasks concerning combating of corruption, like training of investigators, application of norms of criminal law, and so forth. Therefore, these tasks will not be doubled in our plan. Using this opportunity, I want to thank everyone who has given its contribution or will give its contribution for the development of this plan. So if you have any proposals, suggestions, please send us to our bureau. And if you want to look at our plan, it's available at our website. European Commission has approved of measures taken by Latvia to increase capacity of the Bureau to investigate corruption cases. This is also one of the priorities of the Bureau. To empower its capacity, analytical powers, and to do that, at the end of 2020, CNAB received additional funding. Also, we introduced a new remuneration regime. We have approved 90 staff places. 10 of them are from 1st of March this year. Next, from 1st of February next year, 10 from this. So we are talking about risk identification, prevention, conflict of interests, expanding of knowledge in financial analysis methods, in using different tools, in tendencies of using cryptocurrency. We can also say that in the next strategic period, we will have enough resources to provide for implementation of existing goals, and it's our priority. We will try to attract also financing from the EU in order to implement our goals. I would like to turn your attention that everyone from us, in order to decrease corruption in our work and in our life, can report about that to our bureau. Thank you for your attention.
Šī gada sākumā aktīvi iesaistījās šī pretkorupcijas pasākuma plāna izstrādāšanā.
Yes, Telnan Providus was quite active in preparing this plan for the next year, and we are happy that many of these recommendations were taken into account. Maybe due to this, the plan was extended for another year. We still have some time, 5 minutes, because we have not overused our time. But I have one question to Inese Zelča, maybe about this general statement that you mentioned at the very beginning. If you look at the results of CNAB during the last 6 years, in general, you claim that what concerns corruption has improved in the state, in the country. But if we look at our data, for example, in the Transparency International network, or if we look at the Global Corruption Barometer or Corruption Perception Index or Eurobarometer, the situation does not seem to be so rosy. And we would like to claim that this progress or significant improvement has not really taken place. I understand that you are still in the process of preparing this report, but maybe you could today comment what are the measures in your opinion, what are the data, what are the conclusions that can allow to claim that the situation has improved during the last 6 years. Thank you for the question. Of course, if we look at the situation, there can be several points of view. Yes, I agree about the indicators that you mentioned, as well as results that we also know that there is quite a high tolerance towards corruption. Quite many businesses choose to give bribes instead of reporting this to CNAB. But my claim that the situation has improved is more related to the tasks that were included in the guidelines 6 years ago. Because what the colleagues fought for 6 years ago and tried to include in the plan, and there was some opposition to this, and now 6 years later, these things seem just logical to us. When we look at draft laws, we see that various bodies remember that they have to speak about conflicts of interest. They have to include exclusion criteria, for example, in case of competitions. Let's say if someone has been found guilty of being corrupt or having corrupted someone else. So, of course, there is still a lot to do, because there is no single country in the world where everything would be 100% fine and they could just forget about problems of corruption. But if we look at the growth or at the progress achieved since 2015, I think the awareness of what is good, what is bad has significantly improved. Also how to select corruption risks or how to work with corruption risks. Also, as the anti-corruption internal control system, back in 2015, there was a huge opposition to this idea. Then in 2017, there was a huge opposition to the cabinet regulations on this being included as a mandatory requirement. But now we see that most bodies have met this requirement, and now we can move forward and see what is the quality of these plans. Of course, we still have a lot to do in the country, and we are ready to provide more proposals for this plan to be meaningful for the next periods, but there's, I believe, a lot has been done already. Thank you for the answer. We heard this answer, and we should continue submitting proposals to CNAB so that maybe in 4 or so years we could claim that, yes, our awareness, our understanding about what needs to be done to fight corruption have significantly changed, and then and we could agree that there has been significant improvement. Mr. Ransans would like to ask a question. Please, the floor goes to you. I think as a panelist, I can also speak about this after the break, if we don't have time. Now I think we have 2 minutes. If we have 1-2 minutes, I would like to provide a quick comment and maybe ask about the current situation with regards to corruption risk assessments in the various bodies. The Cabinet of Ministers have imposed certain obligations on these bodies, but 2 were left out. These were Prosecutor's Office and courts. And when I took the office, I think that we spoke about this and we discussed this with the Prosecutor's Office and with the court. And then we had these answers, you know, that we have these systems, but we are independent. And the attitude was like, you know, in this particular way, how it has been produced in other countries, we don't need, in other bodies, we don't need this. But I believe that every body, every decision maker has to have a risk assessment, just like in any other body, any other organization. So maybe there is someone from the General Prosecutor's Office or from the courts who could comment this. I would be happy, but we can also ask these questions during commission meetings when, for example, we speak about the budget. We will have the Prosecutor's Office during the second part as well, but Inese Zelča wanted to say something. I would like to say that the cabinet regulations, I think, had an exception that the courts and the Prosecutor's Office should apply this requirement depending on their particularities. But I can praise these 2 bodies because the awareness about this system, the need to have this system, it has improved. For example, currently our colleagues are in active consultation with the prosecutor's office on the introduction of this internal control system. And as far as I know, the court administration has also prepared plans for the judicial system. And I think the Supreme Court also had such a system, such a plan. So in this branch, there's also an understanding about the importance of corruption issues. And they also have to assess the risks and prepare measures. And we can also then speak about the quality during the next during the next period. And let us continue our expert forum. And now I would like to give the floor to the last speaker, Ameet Kabrawala, Federal Prosecutor and Regional Resident Legal Advisor from the U.S. Department of Justice, and works from the U.S. Embassy in Riga, Latvia.
See that soon, and please share your experience and your thoughts about our topic today. Thank you for joining us.
1 second. Mr. Chief Justice, Madam Deputy Head of Mission, Executive Director Tauriņa, members of Parliament, esteemed experts and participants, I'd like to speak about what the rule of law looks like. I have a presentation here. It's not very complicated, but I want to speak about how the rule of law impacts everyday lives of everyday people. When I think of rule of law, I think of judicial efficiency as a pillar of the rule of law. And I often think about my first years as a federal prosecutor in New York City. I was handling a very large volume of cases, very little sleep, and I had a very diverse mix of cases, including cases of financial crime, frauds, tax evasion, sex crimes, smuggling, you name it. I went to court almost every day, and judges would start the proceedings by asking me, the prosecutor, is the prosecution ready for trial? And I would invariably say, yes. The judge would then ask, is the defense ready for trial? And defense counsel would often say, no. There were always reasons for the delay. The defendant was sick, an important witness was unavailable, defense counsel had another trial conflict, the defendant wanted to change lawyers. The case would be postponed. I would come back in 2 months. The judge would ask me the same question, and I would say yes. But of course, the same thing would happen. The prosecution was ready for trial, and the defense again would ask for a postponement, and there would be some other reason for the delay. Now, I don't say this to speak ill of defense lawyers. I used to be one, and some of the best lawyers that I know are defense lawyers. But the fact remains that unless an accused person has an incentive to have her case adjudicated expeditiously, then there is no reason for her case to move quickly through the judicial system. And for the victim of that case, such as a parent or a child in a sexual abuse case, or an elderly person who has been robbed of their retirement savings or defrauded of their savings, there is no justice. When there are continual delays, witnesses' memories fade, cases become harder to prove, and people lose the motivation to continue. And so when we discuss action plans, rule of law reports, and judicial strategies, we should not lose sight of the big picture. How does rule of law impact everyday people in their daily lives? At the end of the day, Latvia, just like the United States, needs a judicial system that functions efficiently and consistently, not solely because of action plans or international standards, but because justice delayed is justice denied. And the victims of crimes are not the only victims of inefficient administration of justice. The public has a strong interest in the administration of justice that is fair, speedy, and independent of considerations that go beyond the facts and evidence in a given case. Now, I want to briefly discuss what makes the United States judicial system function rather efficiently, despite the many challenges that we have. In the United States, a criminal matter typically takes from arrest to the final judgment approximately 7 months. It is quite common in complex cases, even multi-defendant cases, for the final judgment to be issued within less than 18 months. This is the total median number that I've circled, 6.7. As illustrated in this table, the 12-month period beginning in September 30th, 2019, the median duration of criminal proceedings was from arrest to judgment 6.7 months. The median duration of cases where the defendant pled guilty was 6.5 months. The median duration of cases when a judge decided the guilt, that is what happens here, we have both our systems allow for a judge decision or a jury decision, depending on a number of factors. That was 10.1 months. And the median length of trial for proceedings when it involved a jury were 17.9 months. But during the same period of time, the largest financial crime was, in one case, $20 billion, and the average financial crime was $6.2 million. So these figures concern these cases that average 6.2 million, and the largest of which was 20 billion. So both of our systems provide for speedy trial rights. As you all know, criminal procedure law provides that the completion of court proceedings must be done within a reasonable term, that is, without unjustified delay, which depends on the facts of the case. The same goes for the United States. And there's one other procedural rule in the United States that allows for flexibility, which is our criminal procedure rule number 2, which says that the rules must be interpreted to provide for just determination of every criminal proceeding to secure simplicity in procedure and fairness in administration, and to eliminate unjustifiable expense and delay. It's pretty much just like your criminal procedure law section number 14. So what are some tools that I have observed during my last year here that I think are effective and should be used more widely? If someone were to ask me, how can any system reduce backlogs and better assure judicial efficiency while not sacrificing fairness, I would say there's at least 3 things that should be done at a minimum. Number 1, preparatory hearings. I understand that Latvian criminal law, criminal procedure law, does not specifically contemplate the use of preparatory hearings, such as the civil procedural rules do. These are important tools for judges to set expectations, have parties focus on what's important, identify any potential legal issues, such as evidentiary issues that can delay the trial proceedings, and have each side specifically estimate how long they anticipate the trial to last. It puts the onus and ownership into the hands of the prosecution and the defense, even though the judge always remains in charge as the person in charge of the judicial proceeding. There are many judges in Latvia who are already proactively involved in case management. They require the prosecutor and the defense to be prepared, to know each piece of their evidence and the case, and let the court know in advance if there are any legal or evidentiary disputes or problems that might delay the trial. Second, Judges should expect prosecutors to identify which witnesses they want to call to testify, and they should also expect witnesses to be prepared to testify. Our judicial practice in the United States permits both prosecutors and defense attorneys alike to speak with witnesses about the case before a witness testifies, and it permits either the defense, both the defense and the prosecution, to review questions that the witness is likely to be asked either on their direct examination or their cross-examination. Speaking to a witness about their anticipated testimony is permissible, and our rules specifically state that. It's normal and it's good legal practice for a lawyer to know what is going to happen in court, and witness preparation is a fundamental aspect of that. Witness preparation is not witness tampering. Knowing where the line is, but the ethical line is between preparation and coaching begins with hiring practices, hiring and clear ethical codes. And finally, the rules should permit prosecutors to resolve cases fairly and efficiently and transparently through the application of clear guidelines that they can apply when offering or engaging in plea negotiations. In conclusion, no matter who I speak to, wherever it is, I hear the same basic thing. People want a functioning judicial system that functions consistently, even-handedly, and efficiently. Victims want justice. Parties want their dispute to be resolved in a predictable manner. Citizens want an independent judiciary that will follow the evidence no matter where it leads. Latvia has a great legal framework, particularly in the field of criminal justice, as a result of very careful and deliberate action by the Saima and all of the various judicial bodies. In particular, Latvia's legal framework and laws around criminal procedure, anti-money laundering, and asset confiscation are examples of best practices, good examples that can be exported to the rest of Europe, frankly. They allow prosecutors, investigators, and defense attorneys to do their jobs, as well as judges to do their jobs. They are consistent with European standards. But the laws can remain vital only if they are used every day to administer justice in an independent, transparent, efficient, and even-handed manner. Thank you again for your time.
Your opinion and advice. I see that your presentation will be a good ground for expert discussion in our second part of the event. So I'm looking forward for also the moderator to raise questions. Paldies Ameetam Kabrawalam no Amerikas.
Thank you, Ameet Kabrawala from the United States Embassy in Riga, Latvia, for his vision, his suggestions, what should be done to improve everyday life of our people. As it is planned, right now I offer to you break for 4 minutes to air our rooms, drink some water. Let's be back after 4 minutes. After 4 minutes, where we will have our roundtable discussion, where we have invited to participate experts under the lead of our moderator, Lieske de Krijger, and to evaluate the progress of Latvia concerning combating corruption, and also looking back at our discussion organized February last, a year which was based on the corruption index results. After a couple of months, there will be January, and we will present again corruption index results. But let's have a break now and then return back to a couple of minutes.